Good afternoon, everybody. Hope everybody's having a great day. Just a couple of reminders before we get started. Please keep your microphones and your cameras off during today's presentation. If you have questions, please type them in the chat box and I will relay them after the presentation. Also, at the end of today's session the survey will be sent out. So if you could just take a couple minutes to fill that out, provide any feedback or possible topics you would like to have presented on, that would be great. Also, just to make a note, we will not have a presentation next week. That has been rescheduled for December. So we'll skip next week. But with that, I will turn it over to Kiersten.
Thanks, Kylie. So my name is Kiersten Small. I'm an investigator with the North Dakota Department of Labor and Human Rights. I have been with the department just under 10 years now, done a lot of different types of investigations, done a lot of wage claim investigations, employment discrimination, public service of public accommodation, as well as housing. And so I have kind of dabbled into every area that the department does handle. I do a lot of the presentations for the department. And so hopefully it will be able to provide you some great information today, specifically related to a little bit about our complaint process, some of those common complaints we see, and then talk a little bit about background checks. So that's kind of the overview of how we're going to go about today. Like I said, first and foremost, just explain a little bit more about the department and what our complaint process is like, how we go through cases whenever they come in through the department. And then we'll talk a little bit about what those common complaints are. We have kind of every day is different as an investigator. Every single case is extremely different, but we certainly have some of those common issues that we tend to see reappear and happen over and over again. So we'll talk through a little bit of those. We'll talk a little bit about criminal background checks and how they can impact or apply to fair housing situations. And then we'll go through any of those questions and answers. But as Kylie said, if you guys have any along the way, please put them in the chat and we can certainly go through those as well. So first and foremost, the department itself, when I first started the department, I wasn't entirely aware of what they did and didn't handle or what their makeup was. We are an extremely small department. We actually just hired 2 new investigators that started yesterday, but that brings our total of investigators up to 8, fairly small staff. And those 8 investigators handle all of the wage and hour and human rights or discrimination cases throughout the entire state. The department basically is broken into 3 main roles. We statutorily have authority over these kind of 3 pillars. First and foremost is the wage and hour division. That's going to be all of our wage issues. So minimum wage and overtime issues, equal pay, child labor. So any youth employment limitations on young workers as far as their job duties, the hours they can work, things like that. We also handle labor unions, employment agencies, but the item we see absolutely the most is going to be wage collection. So basically, if an employee believes that they have not been paid properly or have not received all of their wages, they can file with our department in order for us to perform an investigation and look into the issues. We also have a section that we oversee regarding independent contractors. And basically what that means is we can look into an employment relationship and determine if based on our laws, if it is that of an employee-employer or of an independent contractor. So that's another piece of that wage and hour division. The next division is the Human Rights Division. This is going to pertain most to discrimination. So this is discrimination in employment, in housing, public services and public accommodations, and credit transactions. Basically, the Human Rights Division, always just think of it, anything related to retaliation or discrimination, that's going to fall under that category. And then we also have authority, basically a legal requirement to provide education and awareness. We do this in many different forms. We have these types of presentations. We have booths that we put on. We do various brochures and fact sheets. We actually just recently updated one of our website fact sheets, and we're looking to expand on those in the coming months. We've made some big changes just to try to make it a little easier to get the information you need and hopefully kind of pinpoint some of those common issues that come across our desk. So when we talk about the Human Rights Division, these are the four main laws that are handled under that Human Rights Division. The first being the Human Rights Act. This is a pretty all-encompassing law that this talks about employment and discrimination in employment, discrimination in public services, which, for example, could be if you believed you were discriminated against in some sort of interaction with the police department or maybe the water services department, and you felt that you were discriminated against, you'd have a right to file. That would be an example of public services. Public accommodations is very similar to public services, but instead of some sort of service being provided, it's more of goods related, so something that you are seeking, whether that's like if you were to go to Walmart or a restaurant and you believe that you were discriminated against, you would have a right to file under that public accommodations law. We also handle credit transactions, and that falls under that Human Rights Act, and there's provisions about retaliation in the Human Rights Act as well. For the Housing Discrimination Act, obviously it's all in the name. That is related to discrimination in housing. So it's any sort of rental or sale transaction related to housing. It can be advertising, it can be kind of the terms and conditions of residing somewhere. All of those would fall under that Housing Discrimination Act. And then the last two pieces of law, those are both retaliation laws, and that is the North Dakota whistleblower law would be if an employee believes that they either reported some sort of law violation or they opposed some sort of law violation, and as a result, they were retaliated against. That is when they could file that whistleblower law under that. The North Dakota Public Employee Relations Act, that is a much more limited category. It's only for public employees. And if it's similar to the whistleblower as far as reporting some sort of law violation, but it has to be in writing and it specifically goes to like an agency head or the Attorney General's office, just a limited number of individuals, and that would fall under those North Dakota Public Employee Relations Act related to retaliation. What we're going to be talking about the most today, obviously, is related to housing. So there's two main laws that we handle with relation to housing. The first one being the Fair Housing Act of 1968. This one's commonly known as the FHA, and this is the federal piece of the law. So this is something that is on the federal side of things, but it basically is all encompassing, covers a lot of different areas related to housing and discrimination in housing. But then we also have the North Dakota Housing Discrimination Act of 1999. This is going to be very similar to the Fair Housing Act of 1968, but it is specifically for North Dakota laws. One of the big differences, I guess, or similarities rather, in the North Dakota law versus the federal law is we have what we call substantially equivalent laws, which means that between the federal law and the state law, it is very, very similar. We actually can investigate cases for HUD, and HUD can investigate cases for us. And as a result, we have to have very similar laws. And so this substantial equivalent law, it means that it's just the same or similar to the federal law. So what exactly are fair housing laws? Why are they existent? It's to make it unlawful to treat someone differently in the sale or rental of housing because of that person's membership in a protected category. Basically to level the playing field. So in order to ensure that individuals are not being treated differently because of some protected category, the fair housing laws are established to ensure that individuals are being treated equally across the board, regardless of any of their membership in a protected category. When we talk about the protected categories, there's the federal protected categories, and then there's some additional state protected categories. When we talk about the federal categories, that's you're going to see on the left side of your screen: color, race, sex and pregnancy, religion, national origin, familial status, and disability. Domestic violence is actually part of the other portion of it, the state category, but under the state law, we have to have obviously the same protected categories as the federal law, but we can, as a state, have above and beyond those laws. So we can have additional protections for certain categories that, again, go above and beyond what's offered on the federal level. So we do have additional categories of age, which is for age 40 and over, and any individual under the age of 40 would not fall under that category. The receipt of public assistance. So if an individual receives some form of public assistance, so it could be Section 8 housing vouchers, it could be North Dakota rent help, any of those public assistance pieces, if they're in receipt of public assistance, we do have protections on basically coverage for them to not be discriminated against because they receive public assistance. We do have the issue of marital status. So whether that's single, divorced, married, whatever the case may be, there are state protections under that. And then our most recent category that has been added is what we call domestic violence. So it's for individuals that are victims of domestic violence that are under a state program. And so it's somewhat of a limited authority over it, but basically it was established to protect individuals if they are in a state program and they are victims of domestic violence, basically to ensure that they're able to kind of move forward with their lease if they have to get out of their lease for any reason or change their lease due to that domestic violence situation. So those are the protected categories. So when we talk about the any sort of discrimination under those, whether it's state or the federal law, those fair housing laws, this is what we're talking about, that the individual cannot be treated differently because of their membership in one of these protected categories. So the department itself, I'll talk a little bit about what the process looks like, kind of what the department's role is in these investigations and what that process of an actual investigation does look like before we get into some of those common complaints. So first off, the role of the department investigator, any investigator that is assigned to a case, their job is to conduct a fair, impartial, and thorough investigation into the facts and circumstances of the complaint. So basically, once a complaint is assigned to an investigator, it's their job to review the information and take a neutral stance. We're not on the claimant's behalf, we're not on the respondent's behalf. We are simply the middleman of sorts that's just evaluating the facts and information and determining, did a violation of either the state or the federal law occur or not? When we do that, we collect additional evidence, we go through the full investigation, and ultimately we're trying to answer the question of, is there reasonable cause to believe that the respondent committed an unlawful act of housing discrimination? So when a complaint is filed, so if an individual believes that they have been discriminated against, they believe that they were evicted because of one of the protected category, they believe they were denied a reasonable accommodation, they believe that they are receiving write-ups or different terms or conditions, maybe they're paying a different amount of rent because of one of those protected categories, then that individual has a right to file. Any individual that believes they have been discriminated against has a right to file a complaint in order for us to look deeper into it. The first step is always to file an intake. So that's kind of the initial paperwork, just indicating, I believe a discriminatory act occurred and this is what happened. Kind of the story, the initial paperwork or form, trying to understand what had occurred. Once we receive that intake, it's the investigator's job to evaluate that information and determine, do we have jurisdiction to move forward with this complaint? So some of the things that we look at for jurisdiction purposes is, is the respondent, are they exempt from the law for any reason? Is it a smaller respondent that only has a few properties? Is it something that it would fall under the exemptions of, for example, like a religious organization or something of the sort? We also look at, did the allegation occur within the statute of limitations? So the statute of limitations for a housing complaint is 1 year from the time that they file. So we obviously have to evaluate, is the information, is the allegation occurring within that statute of limitations? And so if we can determine the jurisdiction, we establish that yes, the allegations that they are alleging would fall under our laws, and that we have what we call a nexus. So the individual has to have some kind of connection between what the alleged action was and their protected category. If they came in and said, I got evicted because the respondent didn't like my shoes, that's not necessarily going to be something that has a connection to a protected category. But if the individual came in and said, I was evicted because the respondent didn't like my shoes because they're a cultural norm of my religion, then that would be a connection or a nexus between the allegation and the protected category. So all of those pieces kind of go in that establishing jurisdiction. If we do have jurisdiction, we would move forward with writing a formal complaint. All that is just a short summary of what the allegations are. So some of the intakes that we receive, they can be several pages. And so once it is filed or once they submit that, it's our job as the investigators to kind of whittle down that information into a complaint that indicates exactly what they're alleging. That I was denied a reasonable accommodation on whichever date, or I believe that I was evicted due to my race, and here are the details. Just a short summary, and it's a good way for the claimant to understand this is exactly what's being alleged, but also when it's sent on to the respondent, it's always a good start to be able to have a clear indication of what the person is alleging. Once we have that summary put together, we send it to the complainant. They would sign the complaint. And once we receive the signed complaint, that is what officially opens the complaint with our department. So before we receive that signed complaint, it is not opened with our department. But once we receive the signed complaint, it's officially open. We send off opening letters and we request the respondent to respond to the allegations, because obviously we have the complainant side of things. And so we request a response to hear what the respondent side of things are. And then the investigation takes place. The investigation, it can consist of many different facets. It will have interviews, we request additional documentation, we have additional correspondence, and ultimately what we're trying to do is determine, based on all of the information we have, we need to make a conclusion of, did a violation of the law occur or not? And so that's kind of what occurs during that investigation stage. And then ultimately we issue a determination out to the parties. And so when we issue that determination, all that is a written report of our findings. So it explains whether we believe a violation of the law occurred or not, and exactly how we came to that conclusion. When we go through this process, one thing that is always going to be emphasized throughout is what we call conciliation, or trying to resolve the issues between the parties at any point throughout the process. Basically, it's a way for the parties to come to a resolution prior to the completion of an investigation, in hopes that hopefully it will resolve the case for both parties as far as be an outcome that they're satisfied with. Once we have that information and we believe we can make a decision on whether or not a violation occurred, then we either, based on the facts and information, believe a violation did occur, in which case we would issue a charge. When we issue the charge itself it's just as if you've ever received anything from court documents, kind of like a summons or something of the sort. It's just a very legal document outlining a summary of what had occurred and how we believed that there was a violation. If we believe that, based on the facts and evidence, a violation of the law did not occur, then we would dismiss the complaint, and basically it would close with the department. But the either party technically can take it on to district court, but generally speaking, if a complainant disagreed with our findings, they could pursue that through district court. And again, conciliation is always emphasized throughout the process. One of the big things about conciliation is if a resolution is reached, the parties can have, we would have what we call a conciliated settlement agreement, and the parties would be able to propose any potential terms to that agreement. And once those are agreed upon, all of the parties sign off on that conciliated settlement agreement, and the department monitors it to make sure that all of the terms get completed. So we'll talk a little bit about the breakdown of our complaints in order to talk more about what those common complaints are. So this is actually for the last 2 bienniums. If you look on the left-hand side, those are going to be the most recent numbers from that 2021 to 23 biennium. But I also included the 2019 through 2021 biennium numbers just for comparison reasons. We really see a lot of kind of similarities from season to season of which cases, what kind of cases are filed, how many cases are filed, and what those resolutions are. As you can see, our cases for both bienniums by far had been resolved by conciliation or coming to those resolutions between the parties. After that, for the most recent biennium, we had 13 that were no reasonable cause, which would mean that we did not believe a violation of the law occurred. 4 of them were reasonable cause. 4 were dismissed. They can be dismissed for various reasons. It could be that we've lost contact with the complainant or something of the sort, but there could be many reasons as to why we may dismiss it. And then we also have a handful that were withdrawn with and without resolution. With resolution would be maybe the parties came to some sort of agreement, not through our department, not through that formal conciliation or conciliated agreement process, but maybe they just talked it out and they decided, yes, they were going to grant my reasonable accommodation, so I want to withdraw my case because we came to an agreement. That would be a withdrawn with resolution. Withdrawn without resolution, it could be various reasons, but it could be that the claimant, when they filed, maybe they are in the midst of many other things going on in their life. They don't wish to proceed forward with the complaint. They don't want to move forward with the complaint for whatever reason. So they may just withdraw the case, even though a resolution has not been reached. So now we can talk a little bit more about what are those common complaints? What are the things that we see the most as far as any sort of housing discrimination case? Because we definitely do have commonalities. We have cases that we see time and time and time again. First off, when we do the breakdown of the issues that cases were filed on, first, if you look at these numbers, first off, they're not going to equate to the 46 cases that we had open. The reason for that is there may be cases that an individual files on more than one basis. So they may say that I requested a reasonable accommodation and I was denied that. And because I had requested that accommodation, I was retaliated against. So it may be disability and retaliation, or maybe I believe I was discriminated against based on my race, my color, and my national origin. All 3 of those might be under the same complaint. But as you can see, by far the most cases that we see are related to disability. And of those disability cases, of the 28 we had, 24 of those were accommodation cases. So we by far see the most related to disability, and really reasonable accommodation is going to be that number 1 issue within that. Likewise, retaliation and public assistance, we see a lot of cases with those as well. So obviously, if disability is the most filed on case, it would be apt for us to talk about what that means. What exactly is disability? So first and foremost, the individual would have to establish that they are disabled under the law. So that under the legal meaning of disability that we evaluate, that they are a person with a disability. So with that, when we look at whether or not they are disabled, we're looking under the Fair Housing Act and the North Dakota Housing Discrimination Act on what is a person with a disability. So the individual must meet the definition under the law, which is an individual who has a physical or mental impairment impairment that substantially limits a major life activity, has a record or a history of such an impairment, or is regarded as an individual with such impairment. So basically, what that means is the individual does have to have some kind of condition that substantially limits a major life activity. Sometimes this is a very easy analysis because sometimes there's visually obvious disabilities, but there are sometimes disabilities that are not visually obvious. So they just because it's not necessarily visually obvious, as long as they can prove that they are substantially limited in some major life activity, that's going to be enough to determine that they are a person with a disability. When we talk about having a record or a history of such impairment, maybe they don't have that substantial limitation right now with their impairment, but they do have a history or a record of having it. So, for example, maybe they have a history of cancer, but they're currently in remission. They may have a substantial limitation at some point, but they don't necessarily have one at this moment. So, that's what that record or history of such an impairment. And then when we talk about the third one, that being regarded as, this is going to be related to an individual that's basically being treated as if they have some sort of substantial limitation, even if they don't. So kind of that perception or that stereotype that we believe you may be disabled in some way. It could be that maybe their family has some sort of history of mental illness and the respondent is treating them as if they have a mental illness, even though they have not been diagnosed with one or they don't have one. Another example could be if an individual, let's say they use a crutch or a walker just for stability reasons, just to ensure that they feel more comfortable on their balance, but they don't actually have a substantial mobility impairment, but the respondent is treating them as such. So those are the three situations when we're talking about disability. That's what we're looking at. So obviously the first thing with regards to any sort of complaint is the person has to be a person that is in a protected class. So in that situation of disability, that's the assessment first and foremost we're going to look at. When we're doing the investigation, we're determining, are you a person with a disability? For the most part, during that kind of initial stage of the intake and determining, do we have jurisdiction to proceed forward of just writing that general complaint? Oftentimes we do very broad assessment of that disability because a lot of that's going to come out during the actual investigation. It's not really very apt for us to do the full investigation on whether or not their condition is a qualifying disability during that first piece. And so that's why we do that assessment during the actual investigation. And then there are some situations in which a respondent may be exempt from some of those fair housing pieces. And so we evaluate that as well. So when we're talking about the most filed on issue, which is the disability, the thing that comes up the most related to that is reasonable accommodations. So reasonable accommodations are changes, exceptions, or adjustments to a rule, policy, practice, or service. Basically, it's some sort of adjustment to the general process in order to eliminate a barrier that's there due to a disability. The fair housing laws do require reasonable accommodations for individuals with a disability, and failure to do so constitutes discrimination on the basis of disability. Basically, these are going to be extremely case by case basis. When you're looking at reasonable accommodation requests, you can have the same the person that has the same exact disability, maybe you have three people that have the same disability that have requested similar accommodations, but may have different outcomes depending on what their substantial limitation is. So it really is something you have to evaluate closely on a case by case basis because it is very much going to vary with any set factors. One big thing to remember with reasonable accommodations is they do not have to be on some sort of prescribed form. They do not have to be in writing. And they also don't have to use some specific or magic words. They do not have to come to you and say, I am a person with a disability under the law and I'm requesting a reasonable accommodation. Obviously, that would be a best case scenario, but they really don't have, under the law, they don't have to provide a very clear and concise statement regarding their request for an accommodation. Something similar to reasonable accommodations that we see less frequently, but it's worth discussing the differences between the two, are reasonable modifications. Reasonable modifications are going to be those structural changes to a unit for individuals with a disability. So these are the actual physical changes to a property. When we look at the accommodations versus modifications, this is kind of just a simple chart of the reasonable accommodations. That's going to be those policies, alteration or changes to rules, policies, practices, or services. And those are going to be generally, cost-wise, they're going to be paid for by the landlord. But generally speaking, there's going to be little to no expense that's going to be resultant of the reasonable accommodation. Oftentimes, it's just those changes to the policy. It doesn't necessarily have a lot of monetary cost in most situations, but one of the biggest differences from reasonable accommodations to reasonable modifications is those modifications. Those are the actual removal of those physical barriers. So the actual changes and alterations to the physical property. And the big thing about this is the costs themselves of those changes, those structural changes, they're generally going to be paid for by the tenant. There are situations, though, if the property is federally supported, if they're receiving some sort of federal support or have some sort of federally supported programs related to it, then those situations, the modifications do have to be paid for by the landlord. But generally speaking, those accommodations are going to be something cost paid for by landlord. A lot of times modifications cost is going to be paid by tenant. So with both of those, we have reasonable modification, reasonable accommodation. What does that mean? So reasonable under the law means that it does not constitute some sort of undue hardship and that it doesn't interfere with the business operations. So when we're looking at that undue hardship, we are looking very closely on, does it impose some sort of undue financial or administrative burden? This is something we look at very closely because it's not just going to be something where you say, oh, the request cost $100. Clearly, that seems like a lot. It's really going to be dependent on what is the financial status of the property. Is it something that's a larger property? Is the management company managing several buildings, maybe even up to 20, 30 buildings? Well, then the cost may be very different than something that is a very small operation that has very, very minimal profit, those type of things. So those are all things that we would look at on whether or not it's reasonable. The other piece of it is, does it interfere with the business operation? So would making that accommodation require some sort of fundamental alteration in the nature of the provider's operation? So would it fundamentally change the way that they are providing services? Even if the answer to any of these questions is yes, the landlord still may be required to provide other options for reasonable accommodations. It's very kind of easy way to think of it is the accommodation process. The respondent has to provide an accommodation that is effective. It doesn't have to necessarily be the accommodation of that person's choosing, but it does have to be effective. One of the biggest issues we see, and we have a couple slides on this because it truly is one of the most prevalent issues we see when it comes, is service animals and assistance animals. These are, as we all think of, service animals, assistance animals, and ESAs, or emotional support animals. Individuals who are disabled may require the use of service or assistance animals, and the disabled tenant may ask for the landlord to basically have an exception or an alteration to that no pets policy. So even if the building is a no pets building, by them asking for a request for an accommodation for an ESA, they are requesting that alteration or change to, can we have an exception to your no pets policy? And to deny the accommodation, the landlord must prove that such an accommodation is not reasonable, not necessary, or causes some sort of undue burden on the landlord. So again, looking at that reasonableness. Is it fundamentally changing the operations? Is it something that's going to administratively be too burdensome, or is it financially too burdensome? A lot of times we have individuals that come and say that the landlord says, well, I don't know that they really needed that accommodation. I don't know that they needed an animal for their disability. Really, some of those assessments, it's difficult because there's a difference between having the documentation that really does indicate the disability related need for an accommodation, or just the landlord's kind of assessment of the information and they making their own assessment saying, no, I don't believe that they need this accommodation. Think of the assistance animals and service animals as kind of basically something that's going to remove that physical barrier or allow them to still have the same enjoyments of the property, regardless of their disability, just the same as something like a wheelchair. So it is truly an assistive aid. Service and assistance animals, there may be a variety of types of assistance animals. It's not always going to be something like a dog, especially when it comes to service animals. There's a very limited scope on what falls under a service animal classification, but assistance animals and emotional support, those can be a wide variety of animals. There's not a set defined, it only can be this, it can only be that. It can be many different types of animals. One thing that we see is that people get, upset. Well, a snake, how on earth could that ever be an emotional support animal? It can be. Just because it isn't for you or I doesn't mean that it's not going to be something that can qualify as being an emotional support animal. There is a lot of information on HUD's website about reasonable accommodations and specifically service animals and assistance animals. It is something that we very much commonly see, and it's a common issue that HUD sees as well. So they really have provided a lot of just great information, paperwork, documentation. The Department of Justice has a great kind of go-to guide and joint statement with HUD about reasonable accommodations related to service animals. But one of the big things is that the housing provider cannot require a person with a disability to pay extra fees or deposits as conditions of receiving a reasonable accommodation. So that means that even if the property does allow pets, if the individual is requesting the animal as an assistance animal or as an ESA, the landlord cannot charge them the additional rent or monetary amount for like a deposit, a security deposit, an additional pet deposit, something of the sort. Like I said, HUD does have some great guidance on this. So if there's ever a question or concern, they really do have some wonderful information that's in question and answer format that could be an easy go-to guide just to refer to before seeking potentially further legal answers, but I think it's just a great way to start. And it's information that we use when we do our investigations as well. We obviously use past court opinions, we use some of this guidance documentation, and all of that is helpful in determining whether or not an accommodation is necessary. Some of the major issues we see related to service and assistance animals, direct threats. Talking about a direct threat, we're looking at what is the actual practicality of that direct threat? Is it just a perceived direct threat, or is there an actual concern for some sort of incident? City restrictions, there are less of them now, but there was a time where there was a lot of breed restrictions specifically related to those dangerous breeds, pit bulls, Rottweilers, Doberman Pinschers, things like that. And when they had the city ordinances, we would have oftentimes landlords saying that, well, the city ordinance does not allow it, so therefore we are unable to provide it as well. That is something that the individual can absolutely reach out and file against the city itself for a discriminatory policy or practice, but as a whole, it's going to be something that really, as a landlord, you want to be mindful of. Even though it may be a city restriction, it's something that the city would pursue towards the individual, not necessarily towards you as a landlord. So again, unless it's one of those undue hardships or one of those financial burdens, it's always good practice to make sure you're mindful of when you're declining any sort of accommodation request, to understand the reasoning behind it. There may be common area issues. So animal that is an assistance or a service animal may be able to go into common areas that wouldn't necessarily always have animals in them. And really what it comes down to, and thought process wise, when you're thinking of these accommodations, really think that these are truly steps that are being taken to eliminate any sort of barriers so that individual has the same enjoyments of the property as other individuals do. So that may impact common areas. It may impact the hallways coming and going. It may impact those community rooms. And it's because, again, those are items that are available for the enjoyment of the tenants. And if you're stating that the tenant cannot be in that space due to, for example, their assistance animal, sometimes it can be problematic because of the fact that it is limiting their ability to enjoy the property in the same way. Requirements of animals. There are always kind of discussion and debate of, well, can we require them to be spayed or neuter? Can we require certain breeds? Can we require certain size or weight limitations? Generally, no. This is going to be something that, again, is going to be kind of having those extra expectations as a condition of a reasonable accommodation. So we will grant your accommodation request if you only have an animal that's under 30 pounds. We will grant your accommodation request if you promise to have the animal spayed or neutered. Those are those additional kind of hoops that an individual would have to jump through as a condition of a reasonable accommodation. So you want to be very careful and mindful of anything related to that. But you can't have absolutely expectations of behavior. Just because it is a service or an assistance animal does not mean that you do not have to have expectations regarding its behavior, how it is interacting within the space. If you are requesting that the owner maintain control over the animal in public spaces, you can absolutely have behavioral concerns. That's just the same as having expectations on a tenant, regardless of their age or their disability. You can have expectations on behavior, even if it is a service or an assistance animal. Some of the big ones that we see related to accommodation issues, pets aren't being picked up after. We've had complaints. The animals are, the owner is not picking up the waste in the common area, the yard area, or maybe they've had accidents several times in the hallways. Again, you can have behavioral expectations. You can absolutely have expectations, even if it's a service or an assistance animal. Working with the tenant and talking about those things absolutely can be something that will be helpful oftentimes in these situations. But again, you can absolutely have expectations, even if it is an assistance animal. Late rent payments due to SSDI payments. So let's say an individual comes to you and says, I need to be able to pay my rent on the 5th because that is when my SSDI payment comes in. That can be a form of a request for a reasonable accommodation. They may be asking because of, for whatever reason, I need to have this accommodation due to my disability. And again, it may be something that you would have to assess. Is it going to cause some sort of undue hardship by granting this accommodation? If not, think about it as that reasonable nature. If it is reasonable, it's likely going to be something that the landlord may have to work through. Too many animals in the unit or uncommon pets. Let's say you have a tenant that has 5 dogs or a snake or a ferret, and you're stating, well, that's just unrealistic. They may need more than one reasonable accommodation or one service or assistance animal. When it comes to an ESA, there may be a reason that they for example, might need three ESAs. One may handle this aspect of their disability. This one may handle a different disability altogether. This one may be for their daughter or son or spouse. So there may be reasons why an accommodation would be kind of that common, just out of the norm situation. There are some situations where if their assistance animal is an animal that needs just biologically thrives with another companion animal with it, there may be a reason why they may need more than one animal in the unit. For example, certain types of rodents or ferrets, they may actually thrive. They take health detriment when they're not raised in pairs. So there could be reasons as to why there's more than one request for an animal, and those really should be looked at on a case-by-case basis, really assessing what is occurring with it. Scented products being used in hallways or common areas. Maybe it's a tenant is putting like air fresheners in the hallway, or the products that they're using are very irritant to their allergies. Those could be forms of reasonable accommodations. They may come to you and say, is there a different way that we could go about this? Is there a different method that I could have to have the cleaning products so that I'm able to have the same enjoyments of the space regardless of my disability? So all of those could be reasonable accommodations that may come into play. So can requests be denied? Yes, absolutely. Requests can be denied, but again, you really want to be looking at these on case by case basis. You want to be looking at, is there some sort of, is it not reasonable? Is there some sort of undue financial or administrative hardship related to it? Is it going to change the alterations of the business? There's going to be kind of a hard spot of, the accommodation has to be effective. It doesn't have to be the accommodation of their choosing, but it does have to be effective. And when it comes to the effectiveness of an accommodation, working with your tenants is going to go a long way in these discussions. But ultimately speaking, if there is some sort of unrealistic, unreasonable nature to the request, or it is going to make those changes, absolutely the request can be denied. So again, when we're looking at that undue hardship, this is kind of the test that we look at is, does it impose some sort of undue financial and administrative burden? Would making that accommodation or modification require a fundamental operation of the nature of the provider's operations? And again, we look at this very closely. Is it going to be something that you have to hire an entire full-time staff member to cover whatever is being requested? Or can you modify job duties within the office? Accommodations aren't always going to be, effortless. They're not going to be something that you have to provide absolutely no effort towards, but oftentimes they're not going to be, these major requests, and they really are going to go a long ways of having a more comfortable environment for the tenant. So can you ask for documentation? The short answer is maybe. So if the documentation received for an accommodation request is not clear, you can absolutely ask for additional documentation that verifies the presence of a disability or explains the specific connection between the requested accommodation and the disability. But as a whole, remember, you're not the doctor or medical provider. If you have a doctor's note that has that clear connection, that's going to usually be enough. That's going to be something that says, hey, they're a person with a disability, they need such and such accommodation for their disability. That can be enough of information that kind of making them to go through that undue burden of gathering additional information to clarify is not necessary. And that can constitute a violation if that does occur. So one of the things that we see very frequently, kind of commonly in various forms, is issues related to discriminatory statements. So what the North Dakota law states is a person may not make, print, or publish or affect the making, printing, or publishing of a notice, statement, or advertisement that is about the sale or rental of a dwelling and that indicates any preference, limitation, or discrimination, or the intention to make a preference, limitation, or discrimination because of race, color, religion, or any of those protected categories. Basically, what this means is that whether it be a written statement as far as like an actual publication, maybe it was a memo or even a text message, or it can be verbal conversations that are expressing some kind of limitation because of the person's protected category. So the kind of some of the examples we'll talk about in a minute here, but basically these are those comments or statements or written pieces that are demonstrating some sort of preference or limitation based on the person's protected category. So keep in mind, statements can be well-intentioned, but may not necessarily be legal. We don't always see issues of blatant negligence. It's not that the individual is just trying to discriminate. It can be something that they're just trying to prevent an issue from occurring again in the future. It can be something like if the individual was a very difficult tenant and they're having kind of a heated discussion upon move out, and the landlord says, I would never rent to a married couple like you guys again. That could be something that's saying, I have a preference, comes the statement comes off as a preference based on a protected category. So when we're looking at these, some of the common issues that we see for these discriminatory statements, the receipt of public assistance, something like refusing to accept any sort of government assistance or refusing to accept certain forms of government assistance. Those are common statement issues that we may see. And a lot of times, again, it's not necessarily ill-intentioned, but it can be related to, is this statement or is this action demonstrating that limitation or that preference because of the receipt of public assistance. Disability, you could see that, maybe a statement relating to a service or an assistance animal where other tenants' dogs are at least paying a deposit and you're not. It could be something that really is showing a preference to individuals who are not disabled. And so we may see issues related to that. Marital status, only wanting married couples because bachelors are a problem. It could go to familial status. Families are too noisy. I don't want to deal with that with other tenants. You guys need to be on the ground floor. You should rent at a different location because it's just too noisy. Again, any of those statements that are showing some sort of preference or limitation because of a protected category. So now we'll move into background checks a little bit. With regards to background checks, so are background checks legal? Yes, it is legal for a housing provider to ask questions about an applicant's background or require a background check. However, anytime a housing provider makes a decision based on an applicant's background information, the housing provider must comply with those state and federal laws. There was some guidance that was released in April of 2016 from HUD about background checks. And actually, just recently this spring in April all the way through June, they were having some public comments and possible changes to some of the criminal background check laws. And so I do think that this is something that over time we might absolutely see changes to in the future. But like I said, HUD does have some great guidance in from 2016 that's specifically related to background checks. So for criminal background checks, in some situations, fees can't be charged. So there's specific situations, again, kind of like the exemptions or the Section 504 related to those reasonable modifications. If there's certain government programs related to it, they can't necessarily always charge a fee for that criminal background check. There's just some of those limited circumstances. And the use of those criminal background checks, it can have a disparate impact. And so when we're looking at whether or not it is a disparate impact, we're looking at those consequences of the action. So basically that the way that they're applying it is impacting a large group of people as opposed to a disparate treatment, which is more of that discrimination truly to a specific individual. Sometimes these disparate impact issues can absolutely be neutral on the surface, but the actual intent or kind of the background behind it actually is not. So for those disparate impact claims, why do they exist? What does that exactly mean with relation to those criminal background checks? Basically, it's saying that if you have a policy that forbids any criminal background check at all, when we look at the breakdown of various races, for example, in the prison system, there is a disproportionate amount of people in certain protected categories that generally have a higher percentage in the prison population versus the general population. So if you look at kind of the federal numbers, individuals that are African American descent may have a higher proportion compared to the general population in the prison system. So if you have an absolutely no criminal background, it can have a disparate impact by basically unfairly and disproportionately targeting individuals that are African American. If you look at North Dakota's numbers, we do have a little bit more limited as far as diversity, but you can see just in kind of the proportions versus the amount in prison versus the general population, it very much can have a disparate impact on individuals that are Native American. And so those are pieces that we would look at as far as, is their policy, is even though it's neutral on the surface, is it truly having a disparate impact? So what can you do with regards to criminal background checks to make sure that you are following the guidance, that you're not having any sort of disparate impact? Looking at things on a case-by-case basis. This is something that you'll do on reasonable accommodations and, criminal background checks, same exact thing. Assess the conviction and the situation on a case-by-case basis. It's not going to be something that will bodes well for a blanket policy. Blanket policies really don't take into account those individual factors that absolutely may completely change the outcome.